Okay, meeting called to order. Any public comment?
No, we have not received any comment.
Okay. May I have a motion to accept the minutes of January 22nd, 2020? And a second?
I second.
Thank you, Angela. Thank you, Joe. All those in favor of approving the minutes? Aye. Opposed? Okay, motion carried. All right.
Do you want to have Ryan introduce himself, and
Sure.
you all introduce yourselves to him?
Yep. Ryan, you want to start?
Okay, I'm Ryan Bradley. I'm citizen of Reading. I'm currently the executive director of United Community Service for Working Families, which has a national youth build aspect to it for students ages 17 to 24, low poverty level. And I'm also a community activist. I've been working with young adults and adolescents since 2008 here in the city of Reading. So that's married, children, grandbabies. So.
I've already had the good pleasure of knowing Ryan, so we don't need introduction. He was actually my boss for a while, for about 6 months when I was working with United Community Services, and I think we're fortunate to have him here. He is a stalwart for young people in the city, and he's one of the Reading's best blessings. So I already know him, and I'm blessed to have known him and work with him.
Well,
Ryan, my name's Ed Stock. I'm the solicitor to the board. I'm a Reading lawyer. Current name of the firm is Rick Stock Law. We're in at the corner of 4th and Oley in the Center Park District. I'm also a resident of the city. I've had the privilege of being solicitor to the board since the inception of the board back in the mid-1990s. You know, my young face notwithstanding, after the city enacted the current home rule charter and the Board of Ethics was established.
Angela, can you adjust your computer so we can see your pretty face?
Can you see me?
Just your, like, from here up.
You can only see half your face, Angela.
Oh.
There you are.
I think I have to sit up higher.
Yeah.
Yeah, okay.
Okay, Angela, if you want to introduce yourself.
Yes, I'm Angela Singletary and resident of Reading. That's about it.
Oh, there's more to you than that. So,
Much else.
I'm Melissa Eggert, newly appointed board chair, lifelong citizen of Reading, 32-year veteran of the Reading School District. So that's me. So welcome.
Thank you.
Let me ask you, Melissa, is Jeff no longer on the board at all? Did he leave, or I didn't know?
No, he was not available today, unfortunately.
Just today. Okay, great.
Yes.
Okay, as far as old business, the board policy. Oh,
I can comment on, I think,
okay.
at least several of these, Melissa.
Okay.
So a long time ago, back in January, we met, and Jim Smith, the investigating officer, was present for part of that meeting. And we had a discussion about the issue of the scope of the investigations. And for Ryan's benefit, under the Code of Ethics, if somebody files a complaint against a city official or city employee alleging a violation of the code, the first step in the process is the complaint is turned over to an investigating officer who's been appointed by the board. In this case, it's Attorney Jim Smith. And what generally Attorney Smith's role is to conduct an investigation to make a determination of whether there's a prima facie case of merit to the complaint. And there's some stops and turns along the way, but if Mr. Smith feels the complaint is outside the jurisdiction of the board or is without any merit, he does have the authority to dismiss the complaint. But if after the investigation is conducted, he feels there's potential merit to it, he issues what's called a findings report, which is then put into the hands of the board for purposes of having a hearing and reaching a decision after taking evidence and testimony of whether there's an ethical violation. The issue that is before us right now is that there was a complaint that the board had a hearing on last year, and the complaint was filed by the complainant alleging a certain violation of the Code of Ethics. And in the course of the investigation, Attorney Smith found other possible violations of the code and included those other violations in the findings report that he issued. So the question that we discussed in January, and obviously that was before your appointment, Ryan, but the question that's pending is really, should the investigating officer be given direction by the board to limit his investigation to only the allegations of the complaint, or should he have discretion to expand the investigation, in a sense, sort of follow the facts of where the investigation leads in pursuing the investigation? You know, there's merit to both sides of the argument. The pros for allowing him to expand the investigation beyond the scope of the complaint would be that, you know, if he discovers during the investigation legitimate violations of the Code of Ethics that should be remedied, I mean, that's a legitimate investigative purpose. On the other hand, you don't want an investigating officer to feel like he's has no limits on his discretion, and in the wrong hands, wrong investigating officer, if they're just given a free rein to do whatever they would like as far as the scope of the investigation, it could lead to problems. Now, Attorney Smith is a very ethical, and I think he tends to be very cautious and conservative, and he's certainly not running amok. But if there would be another investigating officer who has a different mindset, you never know what could happen. So I think we need some guidance from the board as to your thoughts on this. My feeling is that I see the merits of both sides. I would certainly think it would be prudent to constrain the investigating officer to only the complaint that's filed, plus things that are discovered that are directly related to the complaint, and not topics that have no direct relationship to the complaint that's been filed. That way there is some limits on this, but this is a board decision. I'm just, this is just my recommendation. Reasonable people can differ or have differing opinions on this.
Any comments? I agree with you, Ed. I think that, we don't want it to get so broad, especially, and Ryan, you have to know, we were in that hearing for about 5 hours. So it was a very long, drawn out process. And it was our first, was it our first official hearing or second? I think the others were settled second official hearing.
Really, I think it was your second, but it was certainly the most convoluted.
Yeah, so I think that narrowing it to a point, but not so narrow that if something is, turned up in the process is a good idea. Any other thoughts or comments?
I think you guys are reasonable. I think that makes sense. I mean, I think we can go along those lines. I mean,
Yeah, my thought would be to issue this as a board policy. So I would have to draft some language that board could, would have to vote on it at whenever the next meeting is. So you'll have another chance to take a look at it. But I would put this in a board policy that would be guidance for the investigating officer to follow.
that makes sense. Do we need a motion on that? I think that's about the best way to go on that.
No, I don't think so, Joe. I just think as long as I have some general consensus from the board, I can draft something up, and then that'll be more specific for your actual consideration, and that would have to be approved by a vote then.
Sounds good to me.
Everybody in agreement?
Yeah.
Sounds okay.
And
Thank
then,
you, Ed.
And then related to that,
Oh,
item 2 is enforcement of a subpoena. I think this may require an amendment to the Code of Ethics, Code of Ethics is a city council ordinance, Ryan. So we would actually have to go back to city council on this, but there really is no mechanism currently provided. The board has the authority to issue subpoenas to compel the attendance of witnesses to testify, but there's really no enforcement mechanism provided. And I think the investigating officer had a complaint last year and had issued subpoenas, and basically the witnesses just ignored the subpoenas, and there really wasn't much he could do about it. And then I think there was also an issue relating to compelling the attendance of a witness for this hearing last year that you heard about that was 5 hours long. So we have to come up with some mechanism to, I know with a court-issued subpoena, for example, if it's ignored, you can file a motion with the judge to have the subpoena enforced. Since we're not technically a court, we have to come up with something that would allow for the subpoena to be enforced if and when that's necessary. So nothing to take action on here. It's more just something we have to do. And it may require an amendment to the Code of Ethics, which means it has to get in front of City Council. But I will work on that as well.
right. Thanks, Ed.
And on the 2 complaints that are listed there, Shelley, I don't have any information on those. I mean, I suspect nothing's much happened since COVID, but
Yeah, we got letters from Jim January 31st that after his preliminary investigation, he has dismissed both of those complaints.
okay, they've both been dismissed. Okay. All right. There's no action then on those. It's required. The last item, whistleblower amendment. The history on this is that a former city councilman who left office when his term ended, I think was proposing that the city consider adopting an ordinance that would deal with the concept of a whistleblower, provide protections from retaliation for a whistleblower. I was given some direction to draft a proposed whistleblower ordinance for the city. I did that. Truthfully, I borrowed liberally from other whistleblower ordinances from other municipalities that are available online. Didn't really reinvent the wheel. I provided what I drafted to the city solicitor's office, and it's sort of stopped there. They have concerns. I mean, Pennsylvania, and maybe many don't really know about this, but Pennsylvania actually has a whistleblower law already in place that, among other things, does provide protection for retaliation against a whistleblower. So there was some concern by the city solicitor's office that the local ordinance, if adopted, would actually either be preempted by the state law or would somehow conflict with the state law. So I believe the city solicitor, and maybe in part because the councilman who was proposing this is no longer in office, it just doesn't seem that they have any real burning desire to push this issue forward. Since it's not really an issue that the Board of Ethics initiated, I don't really think there's anything further for us to do unless one of you or the group of you would feel differently and want to push this back to City Council for consideration. But, at this point, other than, bringing this to everybody's attention, and unless anybody feels differently, I don't think there's any action that we really need to take with respect to this.
Ed, you said that there's already a whistleblower policy.
Well, there's a whistleblower law. It's a state law, so that, for example, a whistleblower who brings something to the attention of the municipality, like the city of Reading, if there would be retaliation against that whistleblower, they would actually have a cause of action to file in court to seek legal remedies, including damages for that retaliation. So there is a whistleblower law in place. I'm not really sure, truthfully, how widely known that is, that it exists. But the whole concept of whistleblower, with things that have occurred on the national level, have sort of received some renewed attention. But we already have a state law in place that does protect employees of the city of Reading if they are, in fact, a whistleblower. So I personally don't feel that adopting a local ordinance on whistleblower, is necessarily needed because of the state law already in effect.
Thanks, Ed. Any other discussion on that?
Like, we don't need to do anything right now.
No, I
Yeah.
don't think so, Joe. It's just really reporting on it.
Uh-huh.
Okay. So our new business is there is an advisory opinion.
There is.
If everyone got to look at that, I did get to read it.
Ryan, for your benefit, in the Code of Ethics, there is a provision that allows people to submit to the board requests for advisory opinions. So that, in other words, if somebody has an ethical question, rather than undertake the action and potentially suffer the consequences if the action is determined to be wrongful, they can seek in advance an advisory opinion from the board on whatever the particular issue is, and get the ethics board's opinion as to whether the proposed course of conduct would run afoul of any of the ethical provisions of the Code of Ethics. The benefit of doing that is that the advisory opinion can actually be a defense, a good faith defense, if it turns out that the course of action is later on determined to be wrongful and violate the code. So it's a way for somebody to get protection, if they have a situation where they're not quite sure where the ethical boundary lines are. So recently we received a request for an advisory opinion from the assistant city solicitor. there's a local manufacturer who has what are called renewable energy credits. Don't ask me to explain the ins and outs and nuances of renewable energy credits, but this manufacturer apparently has more than it can use and wants to donate these excess credits to the city of Reading. And I believe the city of Reading has some ability then to use these credits elsewhere as far as the city's operations. So the question that's raised is whether or not the donation of these renewable energy credits would constitute a gift, which would violate the Code of Ethics. The Code of Ethics has some pretty specific provisions on when city officials and city employees can accept gifts, and primarily when they cannot accept gifts. So there was some concern with the city solicitor's office as to whether or not this donation would be a violation of the Code of Ethics. You know, I looked at the question. What typically happens when they come in, I write up what I think is the right answer to the question, and then circulate that to the board for consideration. So everybody should have in their packet the advisory opinion that I drafted. The bottom line is that the Code of Ethics puts some restrictions on gifts that are made to city officials, which would be elected officials, and city employees, which would obviously be employees. It does not really have any restrictions that apply to the city itself. So the donation, in my opinion, of these renewable energy credits to the city as a municipal corporate entity doesn't even constitute a gift within the definition of gift in the Code of Ethics. Now, you know, conversely, if these were being given to the mayor, or if they were being given to the president of city council, then there would be a gift that would have to be dealt with. But since these are being donated to the city itself, I don't see any issues as far as the Code of Ethics is concerned with the city accepting the donation of these renewable energy credits. If everybody agrees with the conclusion I've reached and how it's been written up in the advisory opinion, then what I would suggest would be a motion to approve advisory opinion 2020-1. Once that's approved, then I would have Melissa sign it as chairperson, and we would then issue that to the city solicitor, and then they can take it from there.
I read it, and I'm going to move that we approve advisory opinion 2020+1.
I'll second. Any further discussion? All right, all those in favor?
Aye.
Aye. Opposed? Motion carried. Thanks, Ed.
That's all I have tonight.
You need a motion for adjournment?
Do we, Joe's in a hurry. Are you hungry?
I want to watch. Pardon the interruption. My favorite show is coming on, but I'm not.
Oh. What was I going to say? Next meeting date. I think Ed has a couple things he's going to get prepared for us, and then Shelley, you'll let us know when we can meet again.
Yes.
Okay. And I've checked the mail. I've checked the mailbox, and nothing's been in it except for junk mail. So I will continue to check on that.
Thank you.
Yep. All right. So I guess our meeting is adjourned.
Make sure calls together when we get that opinion from Ed when he has something for us to look.